Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Good afternoon. I'm Dave Place, the Vice President and Director at Synergy Lien Resolution Services. I'm excited to have you attend our webinar today. We're going to talk about all things Medicare, how to deal with the conditional payment, how to deal with Medicare Advantage plans, and how even to obtain a refund from Medicare of a final demand you've paid in a personal injury action. I look forward to talking to you about this. My history, I'm an attorney in good standing now, even though I'm not practicing, and Synergy is not a law firm. Before taking over head of Synergy's lien resolution unit about 7 years ago, I spent 15 years as an ERISA recovery attorney, working in all 50 states, doing ERISA work, FEBA, Medicare Advantage, Medicaid, disability, basically anybody who is reaching their hand out to take a piece of your injury victim client's settlement. I was that bad guy. I switched sides and now built a team of people who do nothing but spend all day, every day, trying to protect those settlement dollars you've created for that injury victim. One of the biggest hurdles and currently for trial attorneys to overcome and for their clients to deal with is Medicare. Medicare has what's called the super lien. They're a payer of last resort. We're going to walk through the processes, how to deal with Medicare to make sure that you're both complying and ensuring that your client nets as much as possible. At Synergy, we do a variety of things, and we're only going to talk about Medicare today and lien resolution, but we provide a lot of services to our clients, and lots of them feed into each other hand in glove. As we reduce lien amounts, that provides more money for settlement planning. As we recover dollars to make sure that clients remain on need-based benefits like Medicaid and disability, we have programs to make that available as well. So even though I'm speaking about Medicare lien resolution today, if you have other questions dealing with your client financial circumstances or how to make sure that you're resolving the case appropriately and that your client is netting as much as possible, please feel free to reach out to me directly or anybody at the Synergy team. Medicare conditional payments. Not to sell fear, but to talk about the reality of what's going on with Medicare. Last year, a Philadelphia personal injury firm got in major trouble with the Department of Justice for failing to deal with Medicare. They weren't doing the things you're already doing in your office. They were not notifying Medicare. They were not repaying Medicare. And the Department of Justice came after them. And the Department of Justice attorney said clearly, they're going to hold attorneys accountable to repay Medicare. The result of this lawsuit was you have to do, this law firm had to do what you're probably already doing in your office. Establish a person to handle Medicare claims, to notify Medicare potential third-party benefits available, to notify Medicare of the settlement, and then repay the final demand issued by Medicare. Those are things you'd already be doing. If not, the Department of Justice is going to be looking for you. So make sure you're dealing with that. One of the first things you're going to need to do when your client walks in, if it's on Medicare beneficiary, is have them sign two forms. First is the proof of representation. The second is the consent to release. The consent to release is just a HIPAA form. Your internal HIPAA form will be accepted by Medicare, But the proof of representation is a special Medicare form that you're going to need to download and execute when you return to Medicare. And once you have your client fill out those forms at the initial meeting, you're going to need to report the case to Medicare. You can do that several ways: on the phone, by a fax, via the portal. We recommend using the portal. I will briefly talk about the portal throughout the presentation. Those of you who do not use the Medicare Secondary Payer Recovery Portal, I highly recommend doing so. I will say many negative things about Medicare in the next 45 minutes, but the portal is the one positive thing. If you're not using it, make sure you get on it. It can be quite cumbersome to get onto the portal. You have to do part of it online, then Medicare sends you some passwords through the mail, then you have to reset up again online. It is a bit cumbersome, as everything with Medicare is, but once you jump through those hurdles, it really is a value add to your firm, really increase your productivity, and allow a lot of functionality, and hopefully speed up the process. If you have any questions on that, again, please feel free to give my office a call. We can direct you at least to the link and help you through the process. Interesting fact about Medicare Secondary Payer, and their contractor is BCRC. I hadn't realized this until about 2 years ago. BCRC is run by the Chickasaw Native American Nation. That's why it's in Oklahoma City. That's just an interesting anecdote. I think that's a great thing that we do. So about 2 weeks after you reported the case to Medicare, you receive what's called a rights and responsibilities letter. This is the first letter for Medicare. It just says, here are the rights and responsibilities of the beneficiary, and Medicare will notify you when we have a claim summary. It is key, if you don't get this within 2 weeks, that you call BCRC back. It means they haven't done their job. Literally, their policy asks you to call back the next week to make sure they've done their job. We check on the portal to see if the portal's getting established. If things are working as they should, on the portal, it should show up in about 3 or 4 days, maybe a week, and we'll say in development. That means they're at least doing their job. If you don't have access to the portal, you should get the letter in 2 weeks. If you don't, red flag, give them a call back. And one thing I didn't point out, but I want to return to, is when you're reporting the case to Medicare, you're going to tell them everything about the case, about defense counsel, the injury, the date of loss, and about yourself as trial counsel. This is your one opportunity to try to help Medicare be as accurate as possible in preparing that claim summary. Those of you who deal with Medicare realize that they often include all kinds of unrelated care in their claim summary. I think this part is similar to defensive driving. You can't control the other driver, you can only control yourself. So when you're reporting to Medicare, make sure you tell them it's L4, L5. Don't say bad back. Make sure you say left humerus, not left arm. You want to be as specific as possible. Now, Medicare is still going to make a million mistakes, but maybe they'll make 1 million instead of 1,000,001 because you've done as much as humanly possible. I want to stress that often Medicare mistakes, attorneys will own them as their own mistake, or they'll blame someone in their office. 99% of the time, it is Medicare who makes the mistake. Do not own their incompetence as your own. Okay, after you get the rights and responsibility letter, from that point, every correspondence you send to Medicare needs to have the correspondence cover sheet. On my PowerPoint, it's a link to the actual cover sheet. All these active links will take you to actual documentation you need. The correspondence cover sheet is just a fax cover sheet. That's all it is, with a special name. Everything you need to send to Medicare needs to have that cover sheet, or they're just throwing it away. I'm old enough to remember the original Indiana Jones and the last scene in that when they're pushing the Ark of the Covenant into a gigantic government warehouse full of boxes. I imagine those boxes are full of letters to Medicare without the correspondence cover sheet. They're simply not answering them. So make sure you're using that cover sheet. Now, 65 days after that letter, so you're now 90 days out from reporting the case to Medicare, you get your first conditional payment summary. You're going to want to audit this to make sure it has the correct providers, the diagnosis codes are correct, the dates are correct, and the charges are correct. This is significant. One thing I'll point out here in this process, because the very next step is disputing, is there are some unique ways to dispute in the claim summary. I'm sure all your offices go through these now and look for duplicate care, erroneous claims, or unrelated care being included in the claim summary. The example I always use, we literally had a case with a broken arm, And in the claim summary is a hysterectomy. I joke that's a really bad broken arm. It takes a hysterectomy to fix it. But Medicare simply adds all the bills from the date of incident forward. It's up to us or you to make sure those bills come off. One of the things I want to point out here is a couple unique things that I doubt you're aware of in your office. There's something called the hospital-acquired conditions. It's a list of 14 things that Medicare does not pay for. If they did not exist at the time of admission, Medicare is not going to pay for them. Bed sores, cutting off the wrong leg. As tragic as that is, it's actually listed as a claim. Medicare doesn't pay the hospital to cut off the wrong body part. But if it shows up on the claim summary, as it does, just notify Medicare that this is a hospital-acquired condition payment. They will take it off the claim summary and retract the payment from the provider. That's what's supposed to happen. It happens regularly. We have over 80% success rate in bringing that issue up to Medicare. Another key to doing in disputing is bundled charges. Those of you who look at claim summaries, or those of you who don't have a paralegal that does, make sure you talk to them about this. What happens is Medicare issues a claim summary, and those of you who look at it will see a $10,000 charge listed, but under that charge will be 10 different ICD-10 codes. Of those 10 codes, 8 relate, 2 do not relate. You want to dispute those 2 as unrelated. Medicare cannot split out bundled charges. It's a technical software issue. A case of Ninth Circuit in 2017 says, well, we understand that, Medicare, but you can't make people pay for things that aren't related, so you have to throw out the entire bundle. That means they throw out related care also. This is quite significant. We had a case where I'll talk about refunds later. We're expecting a few $1,000s back in a refund because we were disputing unrelated care through the compromise process. And instead, we got back $54,000, the entire amount of the final demand. Medicare had bundled all the charges. They couldn't unbundle them, so they had to refund all the money. So these are not throwaway arguments. They're not little arguments off to the side. They go right to the heart of Medicare's claim. They have a major impact on getting your case resolved and how much money your clients got to put in their pocket. At the end of the day, that's what we're all here doing. We're at work every day, 40, 50, 60 hours a week, working on lots of cases. Each client of yours probably only has that one case in their whole life. So a few $100s, a few $1,000, $50,000 makes a big difference. So make sure you are dotting I's and crossing T's with this Medicare stuff. It has a major impact. A couple points during the dispute process. You can do this on the portal, which I highly recommend. If you're not doing the portal and you're using the letters they sent you, that's great. When I first started at Synergy, I brought lots of new ideas, and I built a wonderful, in my opinion, and a wonderful worksheet to give Medicare on disputing charges. They hated it. Way too complicated for them. They want it simple, simple, simple. So if you're using the claim summary as your dispute mechanism, which is fine, just make it simple. We draw an X through ones that we think are unrelated, circle ones that we say are related, and put a legend on the front page. Circle is related, X is unrelated. Send it back to Medicare. I think we did in crayon, they'd prefer it. That simple. One thing I'll point out though, if you're doing that, don't use a highlighter. They scan everything and the highlighter will just get erased. So make sure you're doing it in ink in a way they can easily determine it. Nice thing about disputes is you can do it an unlimited number of times. You don't need to add any medical testimony at first. If you submit a dispute, they don't grant it. You can add increasing amounts of medical testimony to get that dispute granted. There's a little caveat to that, and I'll explain that here. During this optional process. This is another process which is very positive, and Medicare, of course, hit it. I'll explain it here. Please, this tends to generate lots of questions. So if you have questions, please feel free to shoot me an email. Happy to walk you through it on the email or set you up with my team to talk about it. What we're talking about is a final conditional payment process. This is on the Medicare portal and is available only the cases that have been reported to Medicare. Every case reported to Medicare is on the portal. So if you report it to Medicare, even via fax, it's going to exist on the portal. But you can't click the buttons to take advantage of this process unless you're on the portal. Here's what happens. It's very similar to a rocket docket in that if your case is set with Medicare and you believe it's going to resolve within the next 4 months, you can click a button on the portal that says, I want to enter into the final conditional payment process. There's two big impacts, one in disputing and one in settlement. This is a nice flow chart. This flow chart actually exists on CMS website. We also have it in blogs on our website. In short, the two big changes are this: disputing. You can only dispute one time during this process as opposed to the unlimited times outside the process. But your dispute must be reviewed and responded to within 11 days. If it's not responded to 11 days, it's automatically granted. Very similar to a request for admission. But the most important part of this process, the most useful part, is for mediation. Think about your cases right now if you're not using this. You sit at mediation table with the Medicare beneficiary having no idea what that client's going to net because you don't know what the final demand claim summary is going to be. I'm sure many of you have war stories of where the conditional payment was one amount, the final demand came back at a much higher amount. That happens regularly. Medicare basically doesn't do their job until you report the settlement, and then they bother to get a final demand together. In this sped up process, there's some timelines. I'll go over them here, but again, the flow chart will go through it. If you have a mediation scheduled, you can download a letter that is good for 3 days. This letter is good for the day of the download and the next 2 days. The letter says, I have a copy of it right here, actually. Yes, here we go, right here. It tells you exactly how long the letter is good for and the exact amount in the Medicare conditional payment. This is not a final demand. This number on this letter will still be reduced by statutory reductions for procurement costs, but it gives you a final conditional payment number, and you can do the math, I'll give you the formulas in a second. You do the math, write the mediation table, and your client can know what they're going to net. It's an unbelievable, helpful tool. Another great benefit of this is that you can see the letters on CMS letterhead. It gives all the dates the defense would need. So defense says to you, once you get the final demand, we'll then start processing the settlement check. No, you can give them this letter right now and say, go back to your carrier, get that check drafted today. A final demand takes about 21 to 45 days to be generated after you tell them about a settlement. So that's why you have these very long delays when you settle a case at mediation or a settlement conference, and your client's asking where the money is, and no one's even issued your check yet. This can really speed that process up. To share a war story, we had a case down in Miami where the conditional payment amount was $300,000 throughout the course of litigation. We did some disputing. When mediation came up, we got online to do this to download this letter, and it was $1,200. Well, frankly, all the parties to mediation didn't believe us. The plaintiff didn't believe us, defense didn't believe us. We almost didn't believe ourselves. It seemed too good to be true. But you flip that on its head and think about how many times Medicare has screwed up to the negative impact of your client. Occasionally, they screw up to the benefit of your client. And yes, we locked it in at $1,200. We paid them like $800 or $900 after reduction of procurement costs, and we're done. It was real. Those oversights happen. This process is not designed to take advantage of oversights. The process is designed to give you surety when you are resolving your case. But we're sure to take advantage of ignorance when we can. How we handle those in just logistically in our office, if we're working with you, we track those with ticklers in our system. When we come 120 days out from mediation, we notify you this process. 30 days out, we can contact you again to see if you want to take advantage of the process. Then we coordinate very closely with your office to make sure the dates stay the same. For example, if you have mediation scheduled for Monday and we download the letter today, then you get a call this afternoon, the mediation's got to be kicked a week. Well, you're out of luck. You get to do it one time. There's no redo. It doesn't negatively impact your client. You're just now outside the sped up process and back in the normal process. So making sure you have those well-coordinated dates is key because you don't want to miss these deadlines. Again, remember that's optional. You don't have to take advantage of that. Now, how to obtain the final demand letter once you've settled the case, if you haven't done the conditional payment amount, or even if you have done the final conditional payment letter, you still report the settlement. You still later report the settlement to Medicare, and they will still issue a final demand. So you still have all this done for you by Medicare. When you report to Medicare, again, there's a link to their form. It's a very simple form. It's a one sheet with five blanks. Settlement date, amount of no-fault coverage, amount of settlement, attorney's fees, and cost. They do all that because they're going to do a calculation under these regulations. One thing I want to point out is that no-fault recoveries are not reduced by procurement cost. So if you get, $25,000 in BI and $5,000 in MedPay, they're going to reduce the $25,000 by procurement cost, but the $5,000 is going to be the amount they're going to want back, because no fault's the idea. There was no procurement cost obtaining that. It was just paid because there was no fault. On occasion, that may cause problems when you report that to Medicare. But let me slow down on that real quick on the payment, the reporting of no fault recoveries to Medicare. On the final detail, settlement detail document, the document you use to report the settlement, there's a blank for no fault settlement dollars. You only put money in there if you actually received the payment from the no fault carrier. If the no fault carrier paid medical bills, then you do not report it there. You only report it if your client actually received the check. The idea being that Medicare paid the bills that no fault should have paid, so Medicare needs to know about it. But if no fault actually paid the bills, Medicare didn't pay them, so there's no need to notify Medicare. That's a distinction that can cause some confusion, so make sure you're aware of that. The Medicare calculations are very straightforward. It depends on whether or not the Medicare conditional payment amount is equal to, less than, or greater than your settlement amount. In short, if Medicare paid more than the settlement, you will get your fees and cost. Medicare takes the rest. Math-wise, you have a $25,000 settlement. Medicare paid $35,000 out in conditional payments. You'll get your fees and costs. Medicare takes the rest. The reverse of that, you have a $50,000 settlement. Medicare paid $25,000 benefits. Medicare will reduce their demand by procurement costs. They add your fees and costs together, divide those by the settlement amount. That's the ratio they reduce by. It essentially is attorney's fees and a pro rata share of cost, how it works. Unfortunately, almost daily we are telling clients Medicare is taking all of your money. What do we do? I'll talk about Medicare refunds in a moment, but that's really the genesis of our Medicare refund service. I was talking to an attorney in the lobby of one of my best clients, a lobby of his law firm, and he said, Dave, I got a case where I'm taking my fee, Medicare's taking the rest. I want to cut a check for 10 grand to my client so they get something. Can I do that? Unfortunately, no. That's Medicare fraud. Medicare bases their repayment on the fees and costs actually paid and charged. So if you reduce your fees or waive costs and don't tell Medicare, they consider that Medicare fraud. Now, to give you a little bit of lack of, to assuage your fear a little bit, Medicare specifically told us there's no Medicare police. They're not coming out and looking at your retainer agreements and your actual invoices to make sure what was paid. But they have said if they find out about it, they do consider it Medicare fraud. Well, after you have a final demand, you have 60 days to make that payment. Nothing tolls that. Not appeals, not waivers, not compromises. You have 60 days. If it remains unpaid in the 60 days, they start charging interest of about 10%. After you make that payment, Medicare will send you a letter saying, hey, we received your check in X dollar amount. Our file is now closed. That is your get out of jail free card. That's the letter that says you're done. So when you have that, you are satisfied with Medicare. That's what you're after. I want to point out that occasionally there's two kinds of closure letters from Medicare. Sometimes you notify Medicare, they'll send a letter back saying, we haven't paid any bills, our file's closed. But often that letter will say, we haven't paid any bills, notify us at time of settlement so we can double check. That's a different letter than saying our file is closed. Make sure you're reading that carefully. If they need to be told, they need to be told. If they say our file is closed, they do not need to be told at settlement. Okay. Medicare Advantage plans, hot topic this day, so let's go ahead and jump into that. Medicare Advantage plans, Part C, Part D. You hear a lot about Part C, less about Part D. Often called MAO plans. They're originally called Medicare Risk HMOs back in the day. This is a product designed, I love talking about this, back in the days of bipartisanship, of Clinton and Gingrich. It's hard to believe that was considered bipartisanship. The idea was Medicare Advantage came online when baby boomers were seen on the horizon. Simply too many people to be managed by Medicare. So we looked to private industry to build a product. This is what we have. Medicare Advantage is a co-op between private industry and the government. They were very similar to Obamacare. They receive a per diem from the government. but they also have risk pools, and they're allowed to charge premiums in addition to the per diem they get from the government. I'm a big fan of the Medicare Advantage service, the product. I think it's a useful tool. For the trial attorneys, it has certain challenges, namely being difficulty in identifying when you're dealing with a Medicare Advantage plan as opposed to regular Medicare. The example I always use are my in-laws. My mother-in-law's on Medicare, my father-in-law's on Medicare Advantage. If you ask them who their insurance carrier is, they both say Medicare. Additionally, they both have the red, white, and blue Medicare card. Every time an individual becomes Medicare eligible, they get the Medicare card. Even if they're on a Medicare Advantage plan, they will have the red, white, and blue Medicare card. It makes our lives a little difficult as trial attorneys to make sure we know what coverage is being used. Also, clients switch yearly. They could switch in October from Medicare to Medicare Advantage or back. Or they could be on Medicare Advantage and stop making premiums. Get back to regular Medicare. So it is a bit of a chore. Frankly, there is no substitute for hard work. The legwork involved here is the same as it's always been. Trial attorneys, we've got to dig down and get the actual answers to the question of who is the insurance carrier involved. You're going to want to read your medical bills, see who's making payments. You want to grill your client for their insurance cards. Give them all the insurance cards. Even if you think I don't need it, get it. Why I say that is because Medicare Advantage essentially now is Medicare. When I was on the other side, we spent 12 years trying to get Medicare Advantage plans to have the ability to use the Medicare Secondary Payer Act as their recovery vehicle. It took a long time. For a long while, Medicare Advantage plans had to use their contract language, which was always very weak. Now things have changed, and Medicare Advantage essentially is Medicare. One of the things I want to point out is the private cause of action. You're hearing about this quite a bit. This is where trial attorneys and plaintiffs are getting sued directly by companies like Humana. As you can see in the slide here, MAOs have the same rights as Medicare. Medicare also has the private cause of action where they can double damages. They simply don't do it. As I said, they go after interest and they go after collections. If your client doesn't pay Medicare conditional payment amount to Medicare, they refer you to Department of Treasury, who then refers you to Pioneer Credit, who then garnishes Social Security benefits and gets quite aggressive. Medicare Advantage plans have other options. They use a private cause of action and are suing plaintiffs and trial counsel directly. A couple of things before we even jump into that, the Medicare Advantage repayment formula. As I said, Medicare Advantage is Medicare. They follow the exact same repayment formula as we discussed a moment ago. I bring that up though because companies like Rawlings, who's a collection agent for Lies Medicare Advantage plans, argue that they do not reduce by attorney's fees and cost. They are wrong. There is no case law to support their position. Their position is this in short. Their contract says they get 100% repayment. Their contract's approved by CMS, therefore they get 100% repayment. As I said a minute ago, we spent 15 years trying to not use the contract as a recovery vehicle, and as soon as they win the big victory, Rawlings turns around and tries to use the contract again. They're wrong. Think about even public policy. Their argument is that private industry gets a larger repayment than the federal treasury. That doesn't make any sense. They have no basis for it. But frankly, it scares me. Not even scare me. I know the reality of the millions of dollars they've been paid simply by saying that. All they had to do was say it, and I guarantee you they've been paid huge amounts of money by asserting that position. Push back on these. The attorney liability. This is something that's especially scary. Again, not trying to sell fear, just trying to make you aware. You are specifically listed as a target to repay Medicare and Medicare Advantage plans. In Virginia, 2016, I was an expert witness in a case where, expert witness in a case where one of our clients was sued directly by Humana for about $400,000. They didn't even bother to sue the plaintiff. Plaintiff probably spent the money, right? They went after the law firm. It was a difficult case. Luckily, we were able to resolve it before the 11th Circuit issued their final opinion in Humana versus Western Heritage. This is the case where slip and fall in Miami. I'll give you quick facts. Right is the case we're getting to resolve. Humana showed up, contacted the plaintiff and said, hey, we have $19,000 in bills we paid. Make sure you pay us back. The plaintiff didn't. Humana started a little bit of litigation with the plaintiff, got tired of that, and sued the third-party carrier, Western Heritage. Western Heritage did what I would have counseled them to do. They put the $19,000 in trust, told Humana the location of trust account, and said, let's litigate this to get an answer from the court. Sounds like a reasonable position by a trial counsel. The 11th Circuit said, placing the money in trust isn't paying. The statute says payment, and the statute says damages shall be double. We have no ability to change that. So if you don't pay in 60 days, you get double damages, and there's no ability to reduce those damages from double. And just as a side note, as I learned in my case in Virginia, double damages are punitive damages, which are not covered by your E&O insurance. So be aware of that. Humana is turning this into a profit center. They were well aware the attorney in Virginia was going to miss the deadline. They waited. From their perspective, they can pay out $10,000 and get back $20,000. Why wouldn't they do that? Of course they're going to start doing that. And who they're doing it against is you and your client. Again, sounds pretty fearful. How do you keep aware of this stuff? Old school legwork. The single biggest red flag, and we use internally too, is if the Medicare conditional payment amount is showing zero. Somebody paid those bills. That's different than the Medicare conditional payment amount is a wrong number. If it's coming back at $8,000 and you think it should be $80,000, likely that's just Medicare making a mistake. It may be somebody else is paying the bills, but probably not. But if you're expecting $80,000 on the claim summary, it's showing zero. Very likely somebody else is paying those bills. So get that bill, look through it. Who's making that payment? Contact your client. Say, do I have all your insurance cards? Make sure you're doing that. I wish I had a better answer for you, but there's hundreds of these plans by dozens and dozens of insurance companies. You simply can't contact them all to find your clients. You've got to get some help from your client or from the medical records, the medical bills themselves. Okay, that was negative, negative, negative. Let's finish with something positive. Medicare waiver and compromise, often called Medicare refund. Now this part is fun, but I'm telling you, you're not going to want to believe me. I often say you're going to feel like I'm selling you the sham wow. But as our president says, believe me. When I joined Synergy, I hadn't done recovery work for Medicare. Medicare has their own internal recovery work. So even though I've been a subrogation attorney for nearly 20 years, this was new to me. As I told you the story of how we came to develop this program, how do we get money back from Medicare? There are 4 ways. Medicare actually does issue refunds. There are 4 ways to do it: appeals, a financial hardship waiver, a compromise, and something called the best interest of program waiver. I'll walk you through each of these. But in short, what I want to stress is that this is real. You can see on this slide, it's a copy of a real check. We put this in our marketing material because we had competitors writing blogs saying, don't believe anybody who says you get your refund from Medicare. It doesn't happen. Well, $5.2 million later, we know it does happen. Frankly, I was pretty nervous the first time too. I hadn't seen a lot of these refund checks, and I didn't want to believe it either. So I share your skepticism, and hopefully I can overcome it. Past 6 years, we've gotten 5 years now. We've gotten about 76% success rate. That means 76% of the time we're asking for money back from Medicare, we're getting it back. We're averaging about 60% of the amount paid back is refunded. How do we do it? The first option is appeals. Now, appeals have deadlines, and appeals are really only useful for 2 things. Either unrelated care is included in the Medicare claim summary, final demand claim summary, or they misapply the reduction statute. That's really the 2 things appeals are useful for. Everything else we'll talk about in a minute. And appeals have deadlines. As you can see, it's a rather long appeal process. We can handle the first 2 level appeals for you. They're paper appeals. The third level appeal requires an appearance. We cannot do that. I said I'm a lawyer. We're not a law firm, and I'm not practicing. But I would say it's decision-making time anyway. But according to the CMS website, it is 28 weeks to get on the docket for an ALJ hearing and 28 months before you get that hearing. So let's try something else while we're waiting. First is a financial hardship waiver under 1870C of the Social Security Act. Then 1862B Social Security Act is the best interest of the program waiver. And the last option we can use is the Federal Claims Collection Act. If we're successful in any of these, Medicare issues a refund. Now, what we're talking about here is at the end of the case. You've taken your fees, you've taken your cost, you've paid Medicare's final demand, you've dispersed the balance to your client, you are done with your representation. We can now go to Medicare and ask for some of that money back. Some of our clients remain involved in the case. Some of us hand their client over to us. Say it's an administrative process, work with Synergy. That's fine either way. The financial hardship waiver is a bit of a misnomer, but what's key about it is it's looking at the totality of your client's circumstances. So you have a 7-figure settlement, doesn't mean your client won't get the financial hardship waiver. We have great cases where that happens. The standard is, would it be against equity and good conscience to require the Medicare beneficiary to repay Medicare? The rest of the bullet points some examples from the Medicare Secondary Payer manual, the actual manual Medicare is looking at when they're determining whether a waiver is appropriate. The second bullet point is my favorite. The beneficiary spent all the money. Now, that's not a very strong argument, but it's actually an argument listed in their manual as an acceptable position. We simply spent all the money. One example at the bottom is the beneficiary is now responsible for grandchildren. We have a story where about 2 years ago on Martin Luther King holiday, a little girl's birthday party was subject to a home invasion. The little girls got away. Their mother was murdered. The grandmother was shot 9 to 14 times, depending on the medical evidence you read. She survived. She got netted over $2 million after fees and costs. A great settlement. Negligent supervision of a housing complex. She was on Section 8. She was in Section 8 housing, on Medicare and Medicaid, and she was now responsible to raise her grandchildren. The Medicare final demand was $170,000. She wrote a 5-sentence hardship letter, which I'll talk about in a minute, in cursive, on torn out loose leaf paper. She filled out a little monthly budget form. We got all of her money back in 30 days. Medicare understands that even though she had 7 figures, this 80-year-old grandmother was now raising 2 grandchildren, and they're expensive. So even though Medicare is incredibly heartless, pre-final demand, after you've paid the final demand, you have an opportunity to have these kinds of conversations and do some good for your client. Now, as I said, your client read a hardship letter. We give them bullet point talking points like this, give them sample letters. Some clients write 10 pages. They want someone to hear their story. Some clients, I said a minute ago, write 5 sentences. Believe me, those 5 sentences were more than enough. It was heartbreaking. But it's a letter your client writes. We don't write it, you don't write it. That serves 2 purposes. 1, I think it's the only letter Medicare bothers to read. And 2, it gives your client a chance to have their voice. I'm an attorney too, so being called a mouthpiece doesn't really upset me. But as a client, and I've been in trial where they want to give me advice on to say in my opening and closing statement. Of course, you can't take that, but it's rather understandable that they want their voice to be heard in their case. This is a chance for that. If you're not successful on a financial hardship waiver, which will either be full waiver or a partial waiver, they will say, we won't waive the whole thing, but waive half of it. We can then move on to the compromise. Now, a waiver is done by internal unit inside BCRC. A compromise is done by CMS themselves, with assistance from HHS attorneys. So you get a much better look at it. And a compromise is more like you're used to writing. The whole kitchen sink goes in there. He's old, she's injured, look at their situation. Medicare, it's not worth your time. Medicare, you might lose. Medicare, there's no fraud involved, which is one of the factors. And you make an offer. Say, Medicare, we offer you $100 to satisfy this. That's our standard offer. In fact, my team often wonders why we can't offer more, but Medicare's jumped to the $100 a few times, so we're certainly not going to offer them more than they'll take less. But typically, 90% of the time, they'll say, Dave, no thanks to your $100, but we'll take $20,000 instead of $50. Here's a $30,000 refund. That happened 76% of the time last year, but you have to ask for it back. Now, if we're not successful in any of those, the appeal didn't work, the hardship didn't work, the compromise didn't work, you have one last shot called the best interest of program waiver. Now, the nice thing for you is, as you finish our presentation, is there's no more to know about this. This slide is all there is. There's no hidden information or more regulations to read. As you remember in law school, it's just an enabling statute. It's just a statute that enables the secretary to waive any claim he or she thinks is appropriate. We don't use this often. This is our last ditch effort. We use it maybe a half dozen times or a dozen times a year. For example, we got a call from the regional director in Atlanta. I don't know if you got to know Betty Noble or not. And her comment was, Dave, why do you keep sending these 1862B waivers in? No one knows what to do with them. I've granted 5 of them in 25 years. I said, well, Betty, 3 of those 5 were ours, so we're going to keep on using them. But we do keep our powder pretty dry. We try other things first. And it really is a solution for the wacky cases. Unfortunately, I bet somebody in this phone call has a wacky Medicare case. They seem to generate wacky cases. A great example here is one we had where Medicare had gone down statute of limitations and no longer had a claim. Of course, they didn't bother to tell anybody that. An attorney had money in his trust account for 8 years. Medicare had stopped responding to him. His client had issued 2 bar complaints against him for not releasing the funds. Luckily, the bar stood behind trial counsel and understood he had to deal with Medicare, but he was stuck. Medicare would not respond. That's very typical of Medicare. They don't have a claim. Why bother to respond? So they left the client and the attorney in limbo for very long. We got it solved in about 4 months under this program. But those kind of situations arise. They can be incredibly frustrating for you in your office. My point is there are solutions out there for Medicare. I tell our people we have several bites at the apple post-final demand. Medicare is a nightmare to deal with, and it certainly can't promise anything positive. In fact, I almost promise the opposite. But you're not without options or with an opportunity to at least present issues to Medicare. So your client may feel that you did all you could, that they were heard, that Medicare wasn't responsive. But frankly, Medicare is rather responsive post-final demand. I think we do get an opportunity to actually listen to what we're being said, and they do their best, I believe, to make sure the beneficiary receives some benefit of their lawsuit. For example, I feel extremely confident in situations where Medicare takes all of the money, that we will get back at least half of it from Medicare. They simply don't like taking more than the beneficiary gets, but they will keep it unless you ask for it back. Well, that's the end of my presentation. I really hope you learned something. I tend to talk a little fast. I tend to talk about lots of things in detail. So if you have questions, if I went too quickly over something, more importantly, if you have a specific case on your desk right now, we could use some support or some advice. I encourage you to reach out to me and my team. We talked about Medicare today, but I have teams for cover military liens, ERISA liens, FEBA liens, Medicaid, disability, state liens. So anybody who's looking for money that you help bring in for your client, contact us and we'll see if we can help. Thanks for your time.